Hello, everybody, and thanks for joining us in the virtual room this evening for this webinar, Above the Law, New Forms of Accountability for Sexual Harassment in the Law. And thanks very much to the Australian Human Rights Institute for making this event possible. I'd like to begin this evening on behalf of all of us by respectfully acknowledging the custodians, the Bedical people, the custodians of this land where we're broadcasting from, the Kensington campus of UNSW. It's a month now since the Chief Justice of the High Court dropped that bombshell that former Justice Dyson Heydon had been investigated for sexually harassing 6 female associates of the court. It was a powerful statement from Susan Kiefel. We're ashamed, she said, that this could have happened in the High Court of Australia, and we have made a sincere apology to the 6 women. Most important of all in that statement was the line that read, "We know it would have been difficult to come forward. Their accounts of their experiences at the time have been believed." For women with the courage to tell their stories of abuse and harassment, no matter the forum, whether it's at home, it's at work, it's on the streets, or it's on the highest court in the land, to be believed is critical. Justice Heydon has strongly denied these allegations, and some will almost certainly be tested in the courts. But apart from the shock of the High Court coming forward with these public findings against one of its own, what really struck me, who's not an insider to your profession, is the realisation that sexual harassment in the law is rife. It is rife and it is known, and yet it still goes on. I've lost count of how many surveys, since this story broke, how many surveys of female lawyers' experience of the law have revealed extremely high levels of female lawyers experiencing sexual harassment in the workplace. One, I recall, I think it was an international survey, said that women working in the law in Australia, 47% had experienced sexual harassment. That's an incredible figure. And that's why we're here tonight. The reality is, apparently, not news to any of you, but it's important that it's talked about, and more than that, that measures to address the culture, change the culture, get rid of this behaviour, to bring in steps to empower women to come forward and make complaints that then lead to action and to change, are discussed and introduced, and for that to happen now. To help us with this discussion tonight, I'm joined on this virtual panel by Professor Andrea Durbach. Andrea is Professor of UNSW Law, where she was Director of the Australian Human Rights Law Centre, now the Institute, for many years. She's held senior positions in the human rights field, including as Deputy Australian Sex Discrimination Commissioner. She also led the major research program Strengthening Australian University Responses to Sexual Assault and Harassment, publishing the recommendations of the project reports on Safe Ground and Local Perspectives in 2018. Also joining us tonight, Dr. Casey McLaughlin. Casey is a senior lecturer in law at Newcastle Law School. She's currently a visiting scholar here at the Australian Human Rights Institute. Her research, broadly defined, concerns the gendered values that shape political and legal institutions and the extent to which law can be used as a tool for achieving equality. And she's recently been awarded the Australian Political Studies Association Best PhD Prize for her thesis titled, and you're going to love this, Situating Women Judges on the High Court of Australia, Not Just Men in Skirts. Also joining us on the panel tonight, Adrienne Morton. Adrienne is President of Australian Women Lawyers, AWL, which is the peak national body representing women lawyers. She's also the immediate past President of Tasmanian Women Lawyers. And during her time with AWL, she's built relationships with other women lawyer organisations across the Asia-Pacific region and as far away as Iceland. And finally, Jane Needham, SC. Jane has been a barrister at the New South Wales Bar since 1990 and was appointed Senior Counsel in 2004. She has appeared in inquests, inquiries and royal commissions, including royal commissions into institutional responses for child sexual abuse, aged care quality and services and disability. Jane was President of the New South Wales Bar Association, and during that time, she oversaw the New South Wales Bar's work on gender equality, anti-bullying and harassment programs. So welcome to the panel. And I know you're all cheering and clapping at home. And before we kick off tonight, some housekeeping. Audience members were invited to leave questions for the panel when you registered for the event. A great many of you have done that, so thank you, and we will try to get as many as we can tonight. But if you are driven to ask a question during this event, you can do so through the application Slido. And also a big thank you to Kathy Wilcox too for giving us permission to use the cartoon His Power, My Safety. So without further ado, let's crack on with it. And first question tonight, Andrea. Andrea, I mentioned the reports and the surveys revealing sexual harassment in the law is rife. What is it about the legal profession that has allowed sexual misconduct to go unseen, apparently, though not so, for so long? Is there really any mystery to any of this?
Well, first of all, thank you, Fran, for the introduction, and to the Australian Human Rights Institute. Thank you very, very much for organising this event. I found it really interesting reading all the comments and listening to news commentary post the findings of the independent inquiry into the former High Court Justice Dyson Heydon. And also what the Law Council have said about this culture of silence and invisibility that tends to underpin this behaviour. And some of the reasons that have been expressed include, and these will be known to everybody, I'm sure, that the legal profession is deeply hierarchical, that there's a sort of enormous power delineation within that profession. There's a culture of, it's a sort of deferential culture, a culture of mentoring, that it's hyper-competitive, and also that many senior roles across the profession, and I'm talking about the judiciary as well as the bar and law firms, are held by men. But you can say that these reasons are germane to many other industries or many other professions where this sort of behaviour is prevalent. Particularly, we all know about the film industry, but in my area of work, which has been, I've worked in this context in the Defence Force and, as you mentioned, in the universities. These reasons are germane to the Defence Force, the universities, particularly in supervisory situations where they're PhD students or in laboratories, but also in another hallowed institution, as we know, the religious bodies. So I suppose the question then is, what is distinctive in addition to all those reasons for the silence that you talk about and invisibility that enables this particular conduct in the legal profession? What is distinctive about the legal profession? And I really wonder whether the answer doesn't lie in the way the profession is organised and operates. That the principles of independence, of upholding justice and the rule of law, of impartiality, you know, that in order to gain entry into the profession, we have to show that we're fit and proper to be officers of the court. It's seen as this career of noble pursuit very often, and that also that once we do gain entry into the legal profession, that there's this requirement for strict observance of fiduciary responsibility, that we actually honour notions quite correctly of confidentiality and trust, and that there's huge loyalty that we have to demonstrate to our client, but indeed to the club as well. And I think all of these factors are now exacerbated by this unregulated online world we're now in, where there's technology-facilitated sexual harassment and violence that is now very much a phenomenon. So, and I suppose one other reason that I want to mention is that I think there's a tradition, particularly in more recent history, of self-regulation within the profession. That's changed. It's become much more of a co-regulated profession. But there is this residue of self-regulation, which basically is a deal that's been done, and I think correctly, with the state that's saying, let us manage the affairs of our profession, because if we want to don't interfere state, because if we want to represent clients who want to hold the state to account, we must feel that we're free and able and independent to do that. So there's very much this justification of self-regulation and a rationalizing that if, you know, you can rely on us to get our own house in order.
Okay, let me bring Casey in here. Casey, I think Andrea's pretty much nailed it. But that question of, you know, there are many structures, many sectors that are hierarchical, that are male dominated, highly competitive is the case. But how do you have a view on how has the evolution of the profession allowed it to operate above the law and enabled this sexual misconduct to become an open secret? Because, talk about a culture of silence. The number of times I've read about, oh, this was an open secret.
I do, Fran, and thank you for the question, and thank you to Andrea for providing a really helpful overview of the profession. The short answer really is in reflecting in the gendered power structures that exist in the legal profession. And to unpack that and provide a longer answer, it's about the extent to which the legal profession is shaped by its history, and it's shaped by its exclusion of women. It's also been constructed on exclusionist terms in terms of race and class as well. And women's entry into the profession was not at all easy. It was hard won. There was huge resistance to women entering the profession. And if we revisit some of those arguments about the resistance to women entering the profession, the idea was that law wasn't an appropriate profession for women because of their purported intellectual inferiority, but also that they would be sexually too tempting to the men in the profession, and also that it would disrupt how we have historically constructed the public and private spheres, that being the public sphere being the world of men, private sphere being the family life.
Yes, but again, Casey, that's historical. The world is such a different place now, and the women in the law, as we've already acknowledged, it's a highly competitive field and workplace, and the women going in are smart and driven, and presumably many of them very highly competitive too. So why has this culture persisted, do you think, Casey?
My argument is that although it is this historical institutional masculinist regime has been very hard to disrupt. And the idea was that as women entered the profession, we would see significant changes. The idea is perhaps add women and stir. And we haven't seen it. Even though women have entered the legal profession in significant numbers since the late 70s and 80s, it hasn't recalibrated power structures. The power has by and large stayed the same.
Jane, would you agree with that? I mean, you're working there day in, day out in a highly competitive environment, a high achiever yourself within that environment. Why has this secret been allowed to just, be there, this behaviour going on unchallenged and, just not spoken about?
Well, it's a very difficult question, Fran. I think one of the issues is that the stats are so significant that I think the NAS report in 2013 indicated that something like 35% of women were sexually harassed in their workplace, their current workplace, and the balance of them, that was on a often regularly, sometimes basis, and the balance of them reported rarely sexually harassed. Very few people, almost statistically insignificant, reported never. And I think that's really important because we hear the stories, the women hear the stories. I have spent the last month responding to survivors of sexual harassment, sexual abuse, and they need to tell their stories to someone. But I think one of the problems is with the hierarchical power-based structures and the gender-based structures that Casey was referring to, we just don't have an easy, welcoming, approachable complaint structure yet. And I'll say yet because of the growth mindset that we hear about from our children. We need to build it, and that's what really we're very focused on doing now. And I think what is very important is hearing the voices of the survivors who've come to us and picking up the difficulties that they have had and taking that forward into a structure which will serve them, not necessarily make people who are already in power happy, but listen to the survivors, work out what they need and reply to that. And I think it's also important to recall that it's not, although it is overwhelmingly women who complain of sexual harassment, 8% of the respondents to the NAS survey were men. And in the last month, I've heard a number of stories of young gay barristers who've had difficulties, and also one straight solicitor who came to me with a story of being sexually harassed by the firm's HR person. And I just find it's a tide, it's a tsunami of complaints, and I think we really need to sit and listen and work on this hierarchical structure that prevents people kicking up, people being difficult, people making complaints.
Adrian, before we move to the important discussion about what can be done, how we get accountability, how we get change, as president of Australian Women Lawyers, I suppose exactly like Jane, I have no doubt you would have had women coming to you since the Justice Hayden revelations in the last month. And what's that made you aware of? Have you been surprised by the number, the incidents, or the culture of the workplace is being described?
Unfortunately, I haven't been surprised at all. And again, this goes back to how ubiquitous it is in our industry. That I wasn't surprised. I was sort of slightly horrified by the numbers involved in the sort of more recent allegations, but not surprised at all. We see it every day.
Let's talk about then what's been the impact of the Hayden allegations. How would you describe the impact of that? Let's stay with you, Adrienne, of that in the month since these have been aired.
I think it's really given because it's been an ongoing problem, it's ubiquitous, although I will say again I think it's the NAS report that where firms have a higher percentage of female partners, they workers report less sexual harassment. So I think as we get more women across the board in senior positions, hopefully we will see a bit of a shift there. But in relation to what has changed with having allegations against somebody so senior in our profession is that it really is being taken seriously, as opposed to, oh yes, he's a bit handsy, or yeah, just stay away from him when he drinks, or don't send your juniors there. It's, oh, actually we have to do something. So I do feel like it is actually putting a little bit more pressure to actually act, as opposed to, hand-wringing and, gosh, isn't it terrible?
Jane, would you agree with that?
I would, and I think one of the, if I can say, beneficial aspects of this very, very high-powered incident of sexual harassment is two things have become really clear. One is that it is a power-based issue. It's not somebody thought somebody was cute and wanted to have a drink with them. It is an exercise of an unacceptable exercise of power. And the second thing is it's going to be much easier to explain to men why it is a problem, because you have incredibly bright, ambitious, clever people in the position of an associate, which is a very highly sought after position, generally for very young practitioners. It's quite often their first job or second job out of law school. And to have that kind of incident, that kind of abuse of power happen to them, it's much easier to explain to people why that is a problem than, perhaps some of the issues that have come to the fore before. And I'm not trying to downplay them, but I think we've seen a number of survivors who've been profiled in the media, both the High Court associates and Danya Mani, who's one of the Supreme Court associates, who've told their story very bravely and have been believed, certainly by the Chief Justice of Australia. And I think that's a really important aspect to it, that someone of the status of the Chief Justice has said the words that you quoted, Fran, at the beginning: we have believed you.
I spoke to another former Chief Justice of the Family Court, Diana Bryant, on the radio soon after this broke. She acknowledged that as a junior lawyer, she too was harassed by a former judge, and she too didn't do anything about it because it didn't seem possible at the time. But she also made the point that she had tried to bring in change in her court, which goes to the point you made, Adrienne, about female leadership within firms or within courts, trying to make change to the associates, the rules around associates. Now, let's bring in one of the audience's questions here. One member of the audience has asked, do we need to rethink the associateship structure in the courts? It seems part of a bygone era and fertile ground for exploitation. If so, what changes could be made? Casey, do you have a view on that?
I do. Thank you, Fran. Noting former Chief Justice Bryant's example, I thought that was a really powerful example of the importance of diversity in leadership and powerful positions, because based on her lived experience, she was able to implement reforms to that particular job description. There are big picture questions about the way that the associate and judicial role works. As Jane has mentioned, often you have a judicial officer who is absolutely at the peak of their profession, and you've got a very early lawyer who's working with them. So that power differential is really significant. And one of the things that you saw in the Chief Justice's letter was some reforms at the High Court level, where they're going to appoint a person who is at least acting as a contact for the associates, so that there is some kind of check and balance on that power dynamic. But there have been other suggestions for reforming the process altogether, that perhaps it doesn't belong in a contemporary legal environment, given that the nature of the work, that perhaps there would be a different way to do it, rather appointing more senior lawyers or appointing different kinds of individuals to work in that close role.
The notion of appointing a point of contact, yes. I mean, what strikes me as someone outside the profession is that's not already there in courts. There aren't already formal mechanisms that exist, safe places for people go to report. Let's talk a little bit accountability about what mechanisms exist now. Andrea, you teach law. I'm sure you're teaching law students all the time about, ethics and behaviour and standards, and what mechanisms do exist currently, and are they working at all?
There are mechanisms. There's solicitor and barrister rules of conduct, which actually make bullying and harassment, sexual harassment in the workplace can lead to professional breaches of that code and professional misconduct arising from that, which could lead to someone being struck from the role or being leaving the profession or getting a severe fine. Within the Sex Discrimination Act, you can bring a complaint of sexual harassment. So there's obviously within law that there's a duty of care possibility as well, a negligence claim, a civil claim. If it borders on sexual assault, then the criminal law might come in and assist. I think what's important in how we shape, very often when people talk about what we should be doing, they rush to policies and say, let's get a policy in place, or a complaint policy in place, or a mechanism. Often, many of the surveys that Jane and others have referred to actually say that despite the existence of policies and complaint processes and training, the figures for sexual harassment and assault within the legal profession go along. They're not that impacted by it. So I think it has something to do with the way those policies are actually designed and executed. And I think we can't just have them as add-ons, which many institutions do have, and say, look, we've ticked the box, we've got a complaint policy or procedure, we've got training in place. They have to be properly executed. They have to be accessible and transparent. They have to define exactly what kind of conduct is being contemplated here. So I think there's a huge amount of work that needs to be done to make those policies effective. And also the procedures need to be fair. I think one of the most important things is the sanctions. The consequences of that conduct must be disseminated. If we want cultural change in relation to this issue, we have to make people aware that this isn't just an aberration by an individual. There's a systemic problem here. There's structural causes that we've all spoken about that has led to this conduct. And we need to make sure that that behavior is changed. And one of the ways of changing it is saying, if you are in breach of these codes, we will make it very transparent, which the Chief Justice of the High Court has done, as you've all said, about what the consequences and the sanctions will be.
Adrienne or Jane, do you have a view on that about consequences? I mean, are there any, and what would need to change to make that happen?
Well, Adrienne, as Andrea has said, Rule 123 of the professional conduct rules does make it a factor that can have you struck off, but it does seem to me there needs to be something in between taking someone off the role in a very formal, there's an investigation, there's a finding by the professional body. It's referred to the tribunal, of which Andrea used to be a member, and which I used to be a member. And then there's a formal hearing to have people taken off the roll. There needs to be something less formal, more effective, more attractive, if you like, rather than that sort of process. And the Legal Services Commissioner in New South Wales does have an anonymous report option where you can go to the website and make an anonymous report of conduct unbecoming. And that is something that is really helpful.
But
not
then
many
what
people
happens?
know about
Once the report is made, then what happens?
Well, the Legal Services Commissioner can investigate. So rather than, having to put yourself out there in a named role and make that complaint, and it could be more attractive for people who aren't willing to be the voice of dissent, because it's not looked on very kindly. I know, and I'm sure Adrienne and the other panelists would have seen this as well. When women complain, they're the ones who are moved on generally.
Adrienne?
Again, yes, I agree totally. It is the costs for women in making complaints are very high. And Kate Eastman noted that women lawyers who suffer sexual harassment are actually less likely than women in, like women working in supermarkets to make a complaint, because they know what the consequences of making the complaint will be, and how haranguing personally the process will be, and also what they've got to lose, and that your supermarket worker is more likely to sort of blithely go in and defend their rights and make the complaint than your lawyer. We also have the issue with things like the conduct rules. I think only now, Tasmania has only recently adopted solicitors' conduct rules in relation to harassment and bullying. So they're not even universal. So we have this system where we have blessed federation, but we have this sort of patchwork of approaches. So another thing that we found is that women lawyers, so let alone people in other industries, women lawyers don't even necessarily know what all of their options are in relation to making a complaint, or what they mostly want is for the action to stop, and so they can just get on with going to work.
Just on that, let's bring in an audience question now in terms of making it stop. This question from a young lawyer: how do I, as a young lawyer appearing regularly in court, deal with inappropriate comments regarding myself or other women, in particular from the judiciary? Jane, let me go briefly to you first on that, and Casey or the others, I'm not sure if you'd like to come in. Jane?
It's really, really hard, because your job as an advocate is to persuade the bench that your case should win and that your case is the best. And if you're sitting there going, "Judge, that's inappropriate, shut up," it's really difficult to get them on side. So you really need, and I've had this one discussion I've had a number of times, is when I was sexually approached by a judge who before whom I was appearing the next Tuesday. And that was really difficult for me, because I had to make that calibration of what do I do now. But the other thing is, it comes back again to that power issue. How empowered are you to make a comment? And one thing I hope that people would do would be to swing in somebody more senior who would be able to do it. Look, Judge, I've seen the transcript, or, someone has contacted me and that's not appropriate. But we should not have to rely in this day and age on the informal approach, because that has absolutely not served us well. But I do not think, until there is real significant cultural change, that will stop. And one of the ways in which I think we will get real significant cultural change is if we harness this moment that we're having now, and get the men involved. Get men to say, no, that's not appropriate, zero tolerance for that kind of thing. I'm not hearing that from all men. I'm hearing it from some men. And calling on you to step up, guys. We need you.
Well, I am hearing it from someone in the audience, actually. This is another question. As a young lawyer in the commercial world, a male and a supporter of women's rights, what can I do to change the culture? Empowerment. No more open secrets. Casey, Do you want to come in? I know you were keen to say something anyway. Do you want to come in on that and more broadly?
I wanted to come in and I would echo Jane's really helpful practical advice, but in talking about the advice for someone who is experiencing sexual harassment, it actually speaks to a wider structural deficiency in our sexual harassment laws, that the onus is on the individual, who is often the least powerful person in the situation, to really move the matter forward. And this is, I think, an important moment to reflect on the Respect at Work report that was released by the Human Rights Commission and its recommendation to impose a positive duty on employers to create a safe system at work. So therefore, the obligation isn't on the individual complainant, but that the actual, the employer has obligations, positive duties, and therefore that might mean that more employees, and including Jane's call to arms for the blokes to step up, it creates a lot more pressure on the institution to step up if there's a positive duty imposed on employers.
It goes to, there's actually another audience question that's just popped up around this. Can the legal profession reform its own culture, or is law reform needed to hold employers and perpetrators to account for workplace sexual harassment? Does that go to what Casey's talking about there, about a positive duty of care on the part of employers? Should that be a legal duty of care? Andrea?
I'm not sure if it can go that far, but I do think that what needs to happen within, and Casey, I'm interested to hear your views on this, but I do think that what the legal profession needs to start recognising is that by not addressing this issue, and particularly in relation to women, but also in relation to the LGBTI community within the legal profession, people with disability, people of colour, that diversity is actually very, very fundamental to the success of the legal profession and the success of law firms and how the community views us. So I would think that if we can start getting the thinking coupled with all the suggestions that Jane and Casey and Adrian have made, if we can start forcing them to think that there's a huge risk to the viability of the profession unless we start looking long term at how we need to, I know we talk about cultural change, but that's what it is. And to see the benefits that will come from actually being so much more respectful and civil. I want to go to something else just very briefly, Fran, that people have mentioned, that also I think a lot of this conduct comes from very dysfunctional workplaces within the profession, and the mental health issues that come up all the time, that actually somehow it's not of a justification, but it might be an explanation for this very, very divergent behaviour and very destructive behaviour, that there's something about the workplace within the legal profession that needs to shift as well to make people not feel that they have to exert this kind of power in this highly competitive environment.
Adrienne, do you think that's acceptable, that it can be dismissed as, you know, oh, well, our workplace is different, it's more pressured, I have to exert myself? I mean, you know, power is power, male power is male power across all number of workplaces, isn't it?
I think it's certainly not justified, but I think it is something that is a justification in people's heads. I bring in this much money for this firm, I'm really clever, everybody says I'm clever, I work hard, and this is my reward. I can do this because everything else balances out, and that somehow, you know, junior female lawyers are some sort of reward for effort. You get, you know, sort of this much back on your billing, and a car and a car space and a phone and a nice office and a view and an intern. And this has to change, because women aren't things and we're not rewards to be doled out. And you'll see you know, there's so many instances where, you know, judges or senior people have asked for, you know, an intern or a research assistant, a young female attractive one. And we see that, you know, Charles Waller Street is not allowed to have, you know, advertised for interns anymore, quite rightly. So that there is that, you know, work hard, party hard thing, and it is part of our culture, and we need to break that down, because it's also, it also is against diversity, because if you have that sort of image of what a lawyer is supposed to be, then women and people of colour and people from, you know, working class backgrounds or immigrant backgrounds don't fit in within that narrow box. So if we privilege that idea of a lawyer, then we're putting down here sort of all of these faces that I see before me, and presumably a lot of the faces that are on the faces of students that are watching us at the moment, and a more diverse profession that doesn't privilege, you know, I do this, so I get that. This sort of, you know, financial or idea of what you do and what you get in your reward. If we challenge that notion that that's what a lawyer should be, we'll start to break that down a bit.
It's very, very similar, isn't it, to the discussion that was had just a few years ago about the medical profession and the surgeons. And it's the same sort of dynamic that Andrea was talking about there, and you've just been discussing, Andrea, and the same sort of connection of these are pressured jobs and, high-powered jobs, and there's mental health, pressure and all of that, that somehow breeds this culture. Adrienne, you were, I think all four panelists were signatories to an open letter that went out to the Attorney General, the Federal Attorney General, and to the Chief Justice, I think, of the High Court, which talked about the judiciary, accountability for the judiciary. So we've been talking more in workplaces, but the judiciary and this notion of some kind of judicial commission. Tell us about, can you, Adrienne, tell us about that idea, and has there been any response? Do any of you know yet from the Attorney General to this?
I don't know if the Attorney General has responded yet, but the idea of a judicial commission and some sort of separate independent body for which complaints about judicial officers could be made isn't new. Most of the states have them. Tasmania doesn't. The Northern Territory has just put in place their act has just been passed just recently. So I think this is actually a natural progression, kind of leading from, the changes to administrative law that we made in the 70s. We have ombudsmen, we have health complaints commissions. This is something that has been progressing since the 70s, and we will get there because this is actually a natural progression of expecting that people who hold office should be accountable.
Jane, I'll come to you in a moment, but Andrea, on that notion of a judicial commission, an independent judicial commission, is that a good idea? I think if I recall correctly, I did raise the notion weeks ago with the Attorney General, who talked about, the separation of powers, the fact that the government can't intervene, or, it's very difficult for the Parliament to intervene. Is an independent judicial commission possible, and is it an answer?
I think it is possible. Yes, there are going to be constraints, but I think there's ways around it. I mean, as Adrienne has says, there are similar or analogous bodies within the states. This will be a federal body, so there will have to be, and Jane, I'm going to need your help here to talk about what the legal constraints might be in setting that up to ensure that sort of independent function. But I do think it's a good idea because it gives a sense of the gravitas with which the profession and the judiciary in particular accords to this kind of conduct, finally, that there is this body now, and not just in terms of sexual harassment, but bullying, which we know is highly prevalent in the profession as well. And so to have some sort of oversight body that has that national standing or federal standing gives a very strong message. And I think a lot, to go back to your former question, Fran, about just what a rupture this was, that a former High Court judge could actually be held to have committed this behaviour, does now call for something very, very, very serious in response. We can't just let it, muddle along as we have with other cases. This is really severe, and there's a huge kind of concern about that something needs to be done in the interest of having trust in the institution of the judiciary.
Jane, do you want to come in on that?
Yes, I do. One of the difficulties in New South Wales with the Judicial Commission here is it's very constrained in what it can do. It can't, for example, discipline judges. It can make findings and they go to the Chief Justice or the Parliament if they're very serious. And if you look at the Judicial Commission website, you'll see the matters that have gone to Parliament were very serious matters of conduct. And the letter from the women lawyers and drafted by Gabrielle Appleby does say that there should be an appropriate suite of penalties. And I think that's a really important point. The other aspect of the Appleby letter, which I thought was really, really interesting, and of course goes to the subject matter under discussion, is the fact that it should be allowed to deal with retired judges, and the New South Wales Judicial Commission cannot. So a judge could say, be caught red-handed as a sexual harasser and resign the next day, keeping the pension, keeping all of the privileges of being a former Supreme Court judge or New South Wales District Court judge, and not ever have this complaint dealt with because it would immediately be dismissed. Now, I'm not a constitutional lawyer, so I have a couple of books over there, but what I don't know how that would be structured, but I do think there should be, you shouldn't be able to avoid it by resigning.
Yes, we need Antumi on the panel for that, and she's not here, yes. But I'm sure someone will be asking her. Casey, I can see you're keen to come in there. I also wanted to ask you, Casey, given the title of your PhD, about another element of that letter, with the 500 signatories to the AG, about how judges are selected, how the judicial selection process, if that's something as part of this discussion. Casey?
Thanks, Fran. The other important proposal that was set out in the letter, of which all of the panellists were signatory, was reforming the judicial appointment process, and certainly the federal judicial appointment process. And that reflects concerns about the lack of transparency and accountability in our current judicial appointment processes. And I think there's an important caveat here that by and large we've actually had a really excellent judiciary, and we've been really lucky in the judges that we've had. But there is really unfettered government discretion when it comes to making judicial appointments. And one of the things that we explored in our letter was really enhancing the value of diversity in a public institution. And having that reflected in a judicial appointments panel or body that makes recommendations or shortlists potential judicial appointees for the government to consider, and doesn't just value legal skill and knowledge, but would of course value legal skill and knowledge, but also personal characteristics like integrity and honesty, and would also really bring in the perspectives of organisations that represent women and other minorities. Again, thinking about a diverse judiciary and how we recalibrate power within our profession.
Okay, I'm sure for a lot of people listening, the notion of how we select judges is probably a bit further removed from where they are right now, and the concerns of the action and accountability measures they'd want to see right now to try and change the culture. And we're talking about, I know it's all in the law, but the judiciary is one element, and then working within the law firms and at the bar is another set of rules, isn't it? So we've talked about, some kind of complaints process, the capacity for anonymous complaints. We've talked about there to be real legal penalties perhaps brought in, and maybe only that would change behaviour. We've talked about putting on employers, the heads of the law firms or the chambers themselves, a positive duty to report. Before I get to some questions, I want to end tonight. We've got some questions from law students in the audience, but if I asked each of you, what do you think is the first step that could be taken to really make a lasting and an actual shift within the short term, not the long term? Changing culture is like turning around a liner often, but what's the first thing that could or should be done? Adrienne, I can tell by the look on your face you don't want this question first, but I'm going to put it to you.
Thank you. I think coming up with the first or one thing that is never going to be, it's one of these things that it's so pervasive that we really have to come up with a range of things. And, it's like the eggs of the basket, or expecting, using a nuclear power plant instead of having lots of little solutions to your power problems. We need lots of small solutions, because trying to find one big thing to pin our hopes on isn't going to work. So it's lots of little stuff. So AWL put out 7 strategies last year, which were things that we, in conjunction with our conbods, worked together. We had a huge session and all worked on things that we thought were pretty uncontroversial and that we could get over the line and could be done without too much expense. So those sorts of things include, having more complaints processes and more options, because one of the things is most people don't actually want to end somebody's legal career. They just want to be able to get on and go to work. So having other options, anonymous, being able to say something anonymously, particularly where you're looking at, I mean, I can think of, a few people who might be in line at some point for, appointment to the bench. And, there's a lot of women who would probably go, I don't think he's a good pick. If we could complain, or me personally, if they could complain anonymously about that person without having to go through a formal complaint and do all of those things, then questions could be raised about that person's character that aren't going to be raised by the head of chambers or, people that know them from the club or because he hasn't sexually harassed them. So there's anonymous complaints. Having a compulsory CPD point is something that we've been talking about. There used to be one, I think, in New South Wales, had it for a while. And also making undertakings so that when you get your practicing certificate renewed, you also do an undertaking that you understand your obligations. So we get it front and foremost in people's minds that sexually harassing their colleagues is not on.
Okay, I'm going to ask each of you this. I'm going to ask you to answer brief way if you can, because I do want to get to the students' questions. So, Andrea?
I think that one way of addressing it, Fran, might be through a tendering process. That if when government puts out tenders for work from the legal profession or from the bar, they used to do, they still do it, I think, but they had a wonderful initiative in relation to showing that firms did pro bono work. You had to show that you had done pro bono work to demonstrate that you could get through the criteria to get possible tender from government or government work. The same should be applied in relation to, you have to demonstrate that you haven't had any complaints against you of sexual harassment, that you've got proper training in place, you've got proper complaint processes in place in order to be eligible for tender from government.
Mm-hmm. That's a good idea. Casey?
I think it's important to acknowledge that no one singular reform is going to solve all of this, but I would continue to agitate for the institutional reforms that we are talking about here, but also to continue to amplify the voices and perspectives of survivors. I think that whatever our path forward in shifting the culture in the legal profession involves listening to survivors and ensuring that they're part of the path forward.
And Jane?
Yes, picking up on what all three panellists have said, no one answer. We need an institutional approach and we need creative approaches. But one thing that I was very struck with when I was working in the Royal Commission into institutional responses to child sexual abuse was the changes to the Royal Commission Act, which provided for private sessions. And these were sessions where survivors could go to the commissioners and tell them their story. And there wasn't necessarily any action taken. No, didn't necessarily become part of the evidence upon which the commission functioned. There would be no findings, but they were heard. And I think if anything has become clear over this last month is there are so many stories out there. And I think the professions, particularly the Bar Association and the Law Society, should be looking at a way in which people can come to them and tell them their stories. And whether it's through an officer that they employ, or whether it's somebody who's a contractor who's going to consult to the association, or perhaps even the presidents and the executive themselves. But the people need to be heard. And as Casey said, the voices of the survivors what need to be heard to direct this process.
Well, it was the voices of survivors in that Royal Commission in particular which really moved the needle, I think, in terms of awareness
Yes.
And change. This brings us directly to another audience question. Do anonymous complaints really exist? Won't they figure out who complained? And is this a barrier? Adrienne?
In Tasmania, in a lot of situations, it would be impossible to make an anonymous complaint because the profession is so small. One of the interesting things they've been doing in the UK, so they've got an app and like a chat bot where and you can make contemporaneous notes essentially with this app and a chat bot. And then if you decide down the track that you want to make a complaint, you've got your contemporaneous note and evidence there. It's one of the hard things when people make complaints about historical allegations is that, well, why didn't you do anything at the time? Or are you sure your memories are correct? So things like that and technology can actually really help us to sort of change some of those things as well, I think.
Okay. In the 10 minutes we've got left, we've got a lot of experience here on this panel, and there are, I know, a lot of law students in the audience. So it would be great to be able to offer them some of the advice from the experience of your shared years. This one from one law student. For law students entering the profession, it's difficult to affect change when we are first and foremost seeking entry into a competitive environment. How do you think we, as the youngest lawyers entering the field, can help to change the culture before we are in any kind of position of power? Now, it goes to all the things we've been talking about, but if you could put yourself in the shoes of a young you, a young lawyer, what do you think young lawyers today could do that might have an impact? Who wants to take this? Jane?
One of the things I learnt way too late in life, after I'd been a barrister for 25 years, is it doesn't really matter if people like you all that much. It does in your friendship environment, it does in your work environments, but when it comes to something where people are trying to undermine you or harm you, it doesn't matter. And that was a really freeing realization on my part. So I'd say to them, work on your relationships within the firm so you have levels of support. But if somebody is harassing you or someone else, don't be afraid to call it out, because there's not enough of that. And we, as older, privileged, generally white people who are standouts in our profession, we have, frankly, let it go on too much because we have wanted not to rock the boat. So if you need someone to come in, go and speak to somebody more senior, but don't be afraid to rock the boat yourself.
And just on that, Casey, I'll bring you in here because I thought one of the most, it's obvious, of course, it's not a surprise, but it is heartbreaking when you read the number of young women lawyers, starting out, obviously got loads of potential. That's why they're in the positions like associates and other positions, quitting the law because of sexual harassment, because of this behaviour, because of the culture. What would your advice be to a young lawyer just entering the profession without the power base?
I thought that was one of the most devastating things to come out of the Hayden allegations, was that the law has lost enormous talent because we've been unable to provide safe systems of work. And it's a really significant problem. And my first instinct to answer this question is that it shouldn't be on the heads of the people entering the profession to transform the culture, that it's for people who already have power within the profession to transform it. I will say, though, as someone who teaches some of the bright, inquisitive young law students that we have today, I'm often really buoyed by their sense of enthusiasm, their sense of equality, and the extent to which I can see them already disrupting those power structures. So I think that it's never too early. At law school, it doesn't have to be a hyper-competitive, negative environment, that there is scope to disrupt some of those norms.
Andrea, do you have a view on this briefly?
I just want to add to what Casey was saying, is that, and to that devastating outcome about young women and men leaving the profession when they've been bullied or harassed. It's the same in the university setting. We are losing amazing talent, research talent, teaching talent, because these young men and women feel that if they do make a complaint, it'll go nowhere. If there is a sanction, it'll be insufficient or minimal, and that they'll be marked as well in their professional lives. So it's the same in that university sector. I think what's important, when I was a young lawyer in practice, it was very important for me to, as Jane says, build those networks and those relationships, but also to get onto committees, to get onto firm committees, their audit and risk committees, and their EDI, equity, diversity and inclusion committees, or whatever those committees are. Get on those committees as young, make your young voices heard, because that's what I did. I used the committee system really effectively. And it was through that we were also able to ask for support infrastructure within a law firm to assist people who wanted to make complaints.
Okay, there's a couple more questions I really want to try and squeeze in if I can. One of them goes to diversity. Adrienne, this one from a young law student: is sexual harassment just the peak of a very large iceberg in the legal profession? And if so, what lies beneath the waterline? Sexism, racism, and elitist thinking?
All of those things. And it's something that as a member of the Chinese Australian community, I'm quite mindful of. In Tasmania, the university has chased the Asian dollar and chased Asian students and wanted to bring them in. But then when they want to stay in Tasmania and make lives and jobs, being able to crack into the profession when they're not white, they didn't go to the right school, they might speak accented English, it's really hard for them. So, and and I've had to in my professional career actually kind of stop people and go, oh, okay, that was actually racist, and it's one of those things that's much easier to deal with when you're more senior, because I can now call out racism, I can call out sexism and not suffer any consequences for it, and restate the culture. But it's something that young people can still do, and also looking out for each other. Don't leave your friends at the legal profession dinner by themselves. Always stick by your mates.
Don't go to dinners is what I'm taking.
Somebody makes a racist joke, call them out on it. Go, what did you mean by that?
Yeah, I mean that you raise the legal profession dinners. From everything I've read as an outsider, there seems to be way too many of these dinners, and they're very dangerous places to be, which takes us back to where we started, I suppose. But just this final question, I think it's all we've got time for, from a law student, and it's actually going back even before you get to the culture of the chambers or the courts. How do we prevent unethical people from joining the profession? As a real-life example, there's a current law student who's been accused of sexual assault and has been cyber harassing other students, but there's no way to report that to the relevant law societies. Jane, what's your response to that?
Oh, I was hoping that one wouldn't come to me. Look, I think there are ways of reporting that to the law societies. There is a requirement that you are a fit and proper person. And I would hope, although I don't know about the Law Society, that there would be a way in which to receive complaints of that kind. And perhaps the app that was being discussed earlier might be a way to keep notes on that. But certainly lawyers have to demonstrate that they are fit and proper to be lawyers. And I think if there were instances of that kind, then that would be something that would be of interest to the bodies, the professional bodies. Again, hopefully out of this process, out of this focus on complaint procedures, we may be able to find a way which will make it easier for that to happen.
And as someone who works in a university at the moment, do you see this as an area where it could be useful to look at standards and behaviour and character before someone goes into the law, or are we really not able to do that?
Absolutely, Fran. I mean, that's why we teach legal ethics across the university sector. Every law degree, every accredited law degree must have ethics as a core course of that degree. And within those teachings, I'm hoping, certainly I teach legal ethics, and I'm hoping we make it very clear. We actually teach a whole class and various classes on notions of gender equality, on diversity, on the complaint procedures. So yes, I think if we can inculcate a notion of that, of what's acceptable behavior before you enter the profession at that stage, it's vital, absolutely vital, and that people take it seriously, that there is a real risk that you won't be allowed admission to be a fit and proper person.
Okay, and someone's noted here, Casey, you've got a view on this. You're telling me some information about someone who's written on this.
I just mentioned that Kate Sear, who's an associate professor at Monash, wrote a great article in response to the Hayden allegations and about how we understand the notion of a fit and proper person, and evaluating what that looks like in light of these allegations.
And do you have a view more broadly about this notion of trying to stop unethical people from starting out on the ladder?
I think that that's absolutely essential. If we can prevent people from coming into the profession who are unethical and lack integrity, that's an enormous step in the right direction.
And a final word from you, Adrienne, on this, or any point you want to make before we wind up, because it is time?
I think in relation to the particular law student that was raising the issue about somebody who has been behaving poorly, definitely see what you can do about making a complaint about that person. And
to whom? To whom? Your lecturer?
To whom? Well, if it was in Tasmania, I'd be suggesting that they complain to the Legal Profession Board. But it's different states, it's going to be different people, and maybe seeking the advice of one of your lecturers.
Okay. Well, it is time for us to finish off. I'd like to thank all of you for being with us tonight. There's been some real ideas brought forward of action. There are moves afoot to try and bring action apart. There's this letter with 500 signatories that's gone to the Attorney General, to the Chief Justice, calling for change at the level of the judiciary. And there's also ideas and moves afoot, I think, within some of the law societies themselves and the courts, the various courts, for better complaints mechanisms, perhaps more anonymous complaints mechanisms. In the end, though, the culture comes down to the people within it, and it might be frightening and it might be dangerous to find your voice, but, you know, the voices have to be heard. And that is a key thing, I think, that we, at this point at the moment, that this is a particular moment in history where we've all been shocked at the revelation from the High Court, and the door is perhaps opened a bit ajar. And men too, I think, a message from tonight. The men in the profession need to lend their voices to this and perhaps make it easier for women to speak out, invite them to speak out and make sure and make it clear that it's safe. Anyway, thank you, all of you, to the panel tonight, to Andrea Durbach, Casey McLaughlin, Adrienne Morton and Jane Needham. Thank you, all of you, for joining us. We do appreciate it. Thank you to the Australian Human Rights Institute for making this happen. And if this discussion is troubling for you, or if you are having troubles, if you are experiencing harassment at the moment, you need support. Support is available for people who need to talk to someone following this discussion. And there's a slide up, I think you can see where you can go for that. So thank you, all of you, for joining us. Have a wonderful evening. Goodbye.
Fran.
Thank you.
Thank you, Fran.